Let me say this, my sister's very compliant.
Yeah, she is.
She got a daughter. Her daughter was one of our other guys, partners.
Got it?
Assistant, and she started raising.
And I guess I need to start off. I'm Nate Jackson, the chair, and we do have our new executive director, Denise Lawrence. Welcome. I'm sure Chairman Roberts going to allow you to have some words a little bit later, so we're going to kind of move on with the report. We have quite a few staff. I see Jason, I see Erica, Huffman, I see Jim, Cameron back there, Attorney Cameron, and Chris Russell, is that right? And I see Bob Weaver. Good morning. I didn't catch her right here. Oh, court report. Oh, I'm sorry. Okay. And we have our Chairman Roberts. We have Commissioner Jim Gavin, Commissioner Stan Norton, and we have Commissioner Carl Kramer present this morning. So with that said and done, I hope I didn't miss anyone. Let's get started. I'm going to relinquish the mic over to Commissioner Norton. He has a few comments.
Thank you, Nate. I do have a few things. First of all, on case 75, the respondent was assessed a civil penalty for $1,500 and is going to have reinspection. The reinspection was going to be done prior to this meeting, and my question is the respondent compliant?
Oh, my recommendation is for a follow-up inspection after this meeting.
After the meeting?
Yes, sir.
So we don't know at that time. Okay.
And if there was a violation in the follow-up inspection, we would open a new complaint, and that would be presented.
Okay. I think you had another comment about the monitoring.
Yeah, I've got a couple of things to go over. I noticed that more than I've seen in the past, there's a lot of cases placed in monitoring, and I've never seen more than a few. There's probably 24 in there. And my question to the staff is there a schedule for this monitoring process? I mean, you guys are busy. The investigators are busy. I just wonder how that works. So.
Well, I mean, a lot of them are in monitoring because we have investigations still out, and so we need to go ahead and get them in the monitoring status instead of keeping them open. And then some of them we're just waiting for investigative reports.
So there's a schedule where
There is.
it's a monitored schedule that.
Yes, sir.
Yeah.
And they would be presented at the next meeting.
Okay.
We're just waiting for the findings to come back, but they would absolutely be presented at our next opportunity.
Okay. Well, the reason I brought it up is just there was a lot more than I've normally seen, so you guys are busy.
It's kind of a new.
We've had a lot of complaints come in the last.
I've handled a lot of. That's the most cases I think I've ever read.
Oh, it's unbelievable.
Yeah, 207.
Thank you.
Yeah, it's a lot.
Thank
of
you
work
for
there.
reading all of them. I know it was a lot.
It was a lot, and you know we appreciate the fact that that you vetted the issues and closed them. Those are the easy reads when they're closed. So, but anyway, I just had to ask. So, one other thing that I noticed there was a lot of was civil penalties assessed for county and city business license. A lot of those. You know, of course, being a dealer, we all are dealers. You know, we're busy, and so it just seems to be a lot of enforcement in that area. My question is, and I'm aware that the license, when you acquire a new license, you are required to provide the city and county license. However, upon renewal, you're not required to present that. So as a dealer, it just seems to be we should be responsible for knowing when our license expired. But is there something we can do in our notifications that we could possibly, when we send a notice out for the license or the grace period time, that we could put a note for the staff to put a note in there to require them to renew their county and city business license? Because I noticed there's a lot. I mean, it just seems to be more cases than I've ever seen. Is that a staff question, Jason?
Well, Commissioner Norton, what we can do is we can add that information to the renewal notice that goes out. And a renewal notice generally goes out about a month and a half prior to a renewal. So we can put a little blurb on that renewal notice that identifies that they need to check to make sure that their city and county business licenses are active and in good standing, just as a courtesy for them. So I think that would be the most cost-effective and effective way to get the information out there, since everybody is going to get that renewal notice.
So you initially require it, but you don't require it for renewal, but we can assess a penalty for not having it, so it seems to stand to reason they'd get a heads up, the fact you got to have it. We're not requiring you to have it, but we can penalize you if you don't. So
Absolutely.
it'd be a nice heads up. Of course, having many dealerships, and some of these guys do, it's you have to keep spreadsheets. It's our responsibility as a dealer to do it, but it'd be nice to get a heads up too.
Make that happen.
Thank you. Got one more?
On my monitor feedback.
One more. Just I noticed on one of the cases, and I don't have the case number here in front of me. Let me see if I do. I think I may. Yeah. Yeah, case number 100. There's issued a letter of a warning outlining advertising guidelines and rules. And I think what that was speaking to was the processing fee not included in the advertised price.
Correct.
Correct. Okay. Just some follow-up on that. Part of our responsibility as a commission is in our mission statements to create a level playing field for all dealers. And this lack of compliance, pretty large in our industry here in Tennessee, creates an unlevel playing field. And I just want to bring that up to ask staff questions about how that's being monitored, how that's being enforced. And I'm aware of the fact that I think on renewal, license renewal, the inspectors are told to inspect for compliance at that time. I've been made aware of at least one case where that's not happening. So my question to the staff is there anything we can do as a commission that could stimulate an initiative for compliance and consistency? Because and just self-inspection of the state of Tennessee on the websites, it's about 50-50, and for the guys that are compliant, which our companies are compliant, and that creates a unlevel playing field for someone who advertises their processing fee to not be included, so they add it to the price. For example, if I advertise a car for $11,000, then my sale price is $10,500. Well, a guy down the street, he advertises his for $11,000, and he doesn't include that in his price. He gets $11,500. So that's a pretty significant impact on the playing field out there for dealers to compete. So my question is, we're a compliance regulation enforcement arm, and I'd just like to know if there's something we could do to level that playing field like we're supposed to.
I'll take a stab at this. I think we're going to look at a lot of different things. I think, as you said, Commissioner Norton, this is a big issue, and advertising, we've gotten a lot of complaints about people saying, I didn't realize that those were additional costs, and they didn't clearly indicate that to me. We're going to talk to our investigators and talk a little bit about continuing education and doing some additional things that they can do when they go out to do their inspections to follow up. And we'll work on something as well from our end to maybe send out some more notifications or press releases. We're working on a press release for tax frauds at tax time, for buyer beware, that sort of thing. And we can work on a number of sort of public service announcements like that, specifically to get it to the dealers.
Of course, well, I'm aware that you're new to this department, and Jason's aware, and there's a lot of people in the room are familiar with what I'm discussing right now. But is there something in place now that the staff knows that we're doing to try to make the dealers be compliant? Is there something? I mean, is there something systematic that can be consistent at this point? Because myself as a dealer, we've been notified, put on notice, and we are compliant. But it's just the guy on either side of me on my street are not compliant. So it's I hate to sound like sour grapes, but it is kind of a bitter pill to swallow.
Right, and I'll say, and then I will absolutely turn it over to Jason. I mean, we rely on a lot of information from you guys, not, and I don't mean just as commissioners, but as dealers, to report to us other people who are not playing by the same rules and who aren't being compliant. I know Jason has spent an inordinate amount of time in the past, literally, searching the internet for people's advertisements and trying to pick out those sorts of things. So I know we do rely on the dealers and to give us information, and I know that Jason does some spot checking, but I'll turn it over to him now.
Well, right now, currently, what we have, our investigators and inspectors, when they go out for inspections, on the inspection form that they use during their inspection, there is, it's an itemization of what they need to check. And part of that itemization is advertising, at least 3, different media forms, if there are 3. So you look at print ads, online ads, things like that. I think what we're going to have to do is, as Denise said, get together with the investigative section and get them comfortable with looking at that advertising. I don't think it's been looked at for a long time, so excuse me. So they may not be as comfortable with it and know what they're looking at when they look at advertising, because as you guys know, advertising is very nuanced. There are a lot of different rules, and they may just not know what they're looking at the time. So continuing education with them, getting them ready to look at those things, I think that's going to be one of our main things that we need to do.
Commissioner Galvin here. On that same things that we're talking about, to make it on the same playing field, I think what we need to do is, before the investigators go out, we need to send a letter out to all the dealers, independent dealers, and just let them know exactly what's going to take place and what's going to happen, and you better have your stuff in order and give them the checklist. That way, when they go over and come out, they already know, the dealers, that, hey, if this wasn't done, then they're going to be fine. But at least let's get to the playing field, let people know. I mean, if we're going to tackle this thing and this is going to be an issue, let's start from the very beginning.
Jim, let me clarify something. He said he used the term independent dealer. Being the only independent dealer here, I'm going to say all dealers. There's
Well, I'm saying all dealers and independent dealers.
Thank you. Just want to clear that up.
I'm not picking on you.
Any more questions?
Number 10, can you explain your decision on that one? You had 2 temporary tags and then a dealer tag. Is that typical here that because I'm fairly new to this, but is that fairly typical that a dealer tag is looked at as a 3rd temporary tag?
Well, it's really not supposed to be out to a customer. A dealer tag is not supposed to be issued to a customer. So really, that's the violation, but
Sure.
it would be a 3rd tag
In essence,
without authorization, yes.
I just was thinking about that, thinking, if the dealer is taking the responsibility of the insurance and keeping them out a little longer when they have a case that's unique and special, as long as, of course, the customer can demand their money back anytime they want and can probably get that remedied pretty easily. But I just wondered if that was the right remedy on this, treating it as a 3rd temporary tag.
Yeah, and there is a question whether it's appropriate. I looked at it as a 3rd plate, as a 3rd tag,
Sure.
because really the dealer is taking responsibility and liability on their own insurance
Yeah.
when they do that. So,
I just ask you to go back and kind of study that one a little bit and see if there's a better remedy, okay?
well,
Case number 17, Commissioner Galvin here. This was a very unusual case. Well, it's not unusual, just the fact that he was overpricing. I was curious on the civil penalty of $20,000, $5,000 for the bill of sale. Can you talk about the fine a little bit?
This dealer, dealer was overcharging for licenses and tags and for title and tags, and not putting the right, I guess, not noting like the processing fee or, you know, whether it was title and tags, and they were overcharging like $40-something per car, and they were saying that it was for travel to and back, for notary fees and all that. That should be in the processing fee. It should be included in the processing fee, because that's all processing the title. Obviously, we know of 4 bill of sales that were like that, and it looks like it's a continuing thing for this dealer. I believe that we went with the maximum on this one for each bill of sale, just to kind of prove a point that this person needs to stop the process.
I agree. I mean, so the maximum is 5,000? That's my question.
Yes.
Okay.
Went for maximum penalty.
We did the 4 that we know of. When the inspector was there, he pulled the 4 that showed it, and I believe they were recent sales. And that's what we're doing, is each bill of sale at the maximum penalty. Whether or not there's more, we don't know, but I would say there probably is. But I think this is more of a penalty to stop this process.
Probably got their attention.
Hopefully.
Any more comments? Any more concerns?
I just have one comment. I thought the staff did a good job resolving a lot of cases. So there's a lot of cases, a lot of hard work there. Appreciate that.
Thank you. On number 10, when you want me to look at the recommendation and the penalty, I guess that one would probably need to go on the next report, the next meeting.
Okay.
So we're going to strike that one out, if that's okay.
I'm not as concerned that you fined him. I just don't know that the remedy or the correct correlation is claiming that it's the third temporary tag. So whatever you want to find, just let us know.
Okay, thank you.
Okay.
One other note, just case number 1 talks about the respondent selling vehicles 10 miles from the dealership at a car wash parking lot and does not have a license for that particular lot. And I noticed that we went on monetary status. I'm just curious how many vehicles he has sold. Have we sent an investigator out? And if so, we probably need to start finding this dude.
We actually just got that investigator report back just a couple of days ago, and he is selling on an unlicensed lot, and they are in the process of becoming licensed, but we will be issuing a penalty. That'll be on the next report.
Any more comments? Any more concerns? Okay. We got another is that the document we got here, this package we just got this morning, it's going to be part of this meeting, or it's in the full? Okay.
It's not part of this committee, no.
Okay, thank you. Well, there's nothing else. I guess we need to adopt the report subject to the full commissioner. Do I have a motion?
Motion to adopt.
Do I have a second? Second. All those in favor of the motion signify by saying aye.
Aye.
And opposed, ayes have it, so ordered. There being nothing else, I entertain a motion that we join.
Motion to adjourn.
Second? Second. All those in favor of join signify by saying aye.
Aye.
Ayes have it. That's opposed.
We'll reconvene at 9 a.m.
Thank you.
All right, let's go ahead and get started. This is a regular called quarterly meeting of the Tennessee Motor Vehicle Commission, dated January 28th, and we are starting at 9:01, if you'll make those notes. And anyway, at this time, I'm going to go ahead and make sure all of us have met our new executive director, Denise Lawrence. And this is her first meeting, and want you all to meet her. And Denise, you want to stand up and tell them anything about yourself?
I'm so and I'm really looking forward. But I'm Rubik's are so much greater than the other commissions in the department, and it's just an honor to be a part of the team. I've been around state government for about 20-plus years, mostly at the legislature. I did do some time here at the department earlier as legislative director, so sort of got the 50,000-foot view, but it is very interesting to get down on this level, and I am so excited, looking forward to working with each and every one of you, and I've visited Chairman Roberts' dealership. I'd love to come visit each and every one of you, just to kind of see how you do things and see what I can learn and what you can tell me you need. So I urge you, please, I'm getting cards printed up, and if I knew my cell phone number, I'd give it to you right now, but I don't. But I think I did email every one of you when I started and gave you my personal cell. So please, please use that if you ever need to get in touch with me. And obviously, we're here to help. Thank you.
All right, who would like to call the roll?
Mr. Chairman, I would love to call the roll. Chairman Roberts.
Here.
Commissioner Galvin.
Here.
Commissioner West.
Here.
Commissioner Fox.
Here.
Commissioner Kramer.
Here.
Commissioner Jackson.
Here.
Commissioner Melton.
Here.
Commissioner Murray.
Here.
Commissioner Norton.
Here.
Commissioner Vaughn.
Here.
Commissioner Tomaso.
Here.
Commissioner White.
Here.
Commissioner Evans.
Here.
Commissioner Barker.
Here.
Commissioner Banian.
Here.
Almost got it right. We have a quorum.
Very good. Meeting notice. Is that something you're going to handle?
I'm told this is something I need to read into the record. This meeting's date, time, and location have been noticed on the Tennessee Motor Vehicle Commission's website, included as part of this year's meeting calendar since October 22nd, 2019. Additionally, the agenda for this month's meeting has been posted on the Tennessee Motor Vehicle Commission's website since January 22nd, 2020. This meeting has also been noticed on the TNGov website.
Good. Do we need a motion? Do we need to vote anything in at this time? Okay. Next, we need to adopt the agenda for the meeting today.
Motion to adopt the agenda.
Second.
Any further discussion? All those in favor say aye.
Aye.
Opposed? Like sign.
Second.
Who seconded it?
Commissioner Norton.
And we also need to approve the minutes from the October 2019 meeting.
Make a motion to adopt the minutes for the 2019 meeting.
I second it.
Any further discussion on the minutes? All those in favor say aye.
Aye.
Like sign? Okay. All right. All right. I guess the next item is informal appearances for salesmen and dealers appeals.
That's right. If you allow me to do a quick overview. The first one is Christopher Roach. In the case of Mr. Christopher Roach, the relevant documented convictions are for fraudulent use of a credit debit card less than $1,000 on February 21st, 2013, and criminal impersonation of an officer on April 6, 2013. From the documents received by the Commission, it appears that the applicant received a Class D felony and a Class A misdemeanor and was ordered to 5 years of supervised probation. This application may be denied under Tennessee Code annotated 5517-14A1C until November 7, 2021.
Is Mr. Roach here? You will vote to deny the request?
I would like to make a motion that we uphold the staff's denial.
Okay.
Further discussion? All those in favor say aye.
Aye.
Opposed? Okay.
Next is Robert M. Stafford. In the case of Mr. Robert Stafford, the documented conviction is for domestic assault on January 9, 2019. From the documents received by the Commission, it appears that the applicant received Class A misdemeanor on June 12, 2019, and was ordered to 1 year of supervised probation. This application may be denied under Tennessee Code annotated 5517-14A1C until June 11, 2025.
Mr. Stafford here.
Commissioner Jackson, motion that we adopt the staff report,
I'll
or the
second.
staff recommendation.
I'll second it.
Okay, any further discussion? All those in favor say aye.
Aye.
Opposed? Okay.
Next is Carrie Kenworthy. In the case of Miss Carrie Kenworthy, the documented convictions are for obtaining a controlled substance by fraud, 3 counts of worthless checks between $500 and $1,000, and theft of property greater than $10,000 but less than $60,000, and 5 counts of theft of property greater than $1,000 but less than $10,000. From the documents received by the Commission, it appears that the applicant received 1 Class C felony, 2 Class D felonies, and 2 Class E felonies. This application may be denied under Tennessee Code annotated 5517-14A1C until April 14, 2025.
Mr. Kenworthy here. Miss? She,
Yes.
okay. So she's not here?
I'd like to make a motion that we uphold the staff denial.
I'll second.
Any further discussion? All those in favor say aye. Aye. Opposed? Okay. Next.
Robert Self. In the case of Mr. Robert Self, the documented conviction is for 5 counts of aggravated burglary in 2011. From the documents received by the Commission, it appears that the applicant received a Class C felony. This application may be denied under Tennessee Code annotated 5517-14A1C until January 5, 2034.
Is Mr. Self here?
Make a motion to uphold the denial of staff.
Second.
Any further discussion? All those in favor say aye. Aye. Opposed? Has that ever happened that we had all no shows?
Never happens.
Wow. Okay. Okay, Executive Director Lawrence, would you like to deliver your first director's report?
I would. I would love to do so. As of the last meeting, which was in October of 2019, we've had 73 dealers opened or relocated for the last quarter. There are approximately 24 applications in process, and here's a list of our active licenses as of January 6th, 2020. We have 3,678 dealers, 29 auctions, 134 distributors, manufacturers, 16,848 salesmen, 562 representatives, 252 dismantlers, RV dealers, we have 40, 76 RV manufacturers, and 3 motor vehicle show permits. We've had a number of complaints opened, 122, and of those, 72 have been closed. The annual sales report, which is due February 15th, we have vehicles that reported sold in 2018 that is ongoing right now, as well as recreational vehicles. The total online sales report collected is 562, and the last annual sales report collected is, again, deadline February 15th, so we don't have anything available at this time. However, those are coming in with some frequency. We have been performing, as I mentioned earlier, well above our metrics that we have been asked to reach. We're averaging approximately 2.3 days in licensing individuals, and we have our compliance record rate is at 93.58% as of November of last year. We have a quarterly satisfaction rating of 97.3%, and I might add that literally having been here just a little over a month, I've gotten no less than 2 emails directly from Lieutenant Governor McNally's office and another legislator praising our staff for their assistance and their willingness to go the extra mile, and I just can't tell you how much that pleases me. So I'm proud to be a part of this group. Thank you.
That it for the report? Okay. Do we do a voice vote or a roll call on this one?
Commissioner Jackson, just point of privilege. I think she forgot the dismary on your second page.
Oh, absolutely right. I was so excited to get to the end. So far, we've collected $65,500, and we have an adoption rate for online performance at 95.24%. The total 65.5 is what we actually have received, but we have quite a bit more outstanding, and as you can see from this most recent legal report, a good deal more after this goes into effect. So I think we can do a voice vote.
What's your pleasure,
Commissioner Jackson,
Director?
motion to adopt the director's report.
Second.
Who seconded it? Okay. Any further discussion? All those in favor say aye. Aye. Opposed? Okay. Director's report is adopted, and next is the legal report, and I believe that Ms. Smith and Mr. Huffman will present that.
Yes, the Legal Review Committee met this morning. We had a very lengthy legal report. There was only one change, and that is 2019-073-971. It's number 10. There was an issue about a dealer plate being issued as a third temporary tag, and the recommendation was to authorize a civil penalty of $500 for issuing a dealer tag as a third temporary tag. We discussed it, and we believe that if the dealer chose to give out a dealer plate instead of a tag, he was trying to do the right thing, but of course he incurs a lot of possible liability by doing so. So we've decided to do a letter of warning for misuse of a dealer plate, and that's the only change that we had on the legal report. All other recommendations were adopted.
Pleasure on the legal report.
Commissioner Jackson, motion that we adopt the legal report as discussed with the change.
Second.
Any further discussion? Let's have a roll call vote, please.
Commissioner West?
Yes.
Commissioner White?
Yes.
Commissioner Murray?
Yes.
Commissioner Melton?
Yes.
Commissioner Chobanian?
Yes.
Commissioner Barker?
Yes.
Commissioner Fox?
Yes.
Commissioner Galvin?
Yes.
Commissioner Norton?
Yes.
Commissioner Vaughn?
Yes.
Commissioner Jackson?
Yes.
Commissioner Kramer?
Yes.
Commissioner Evans?
Yes.
Commissioner Tomaso?
Yes.
And Chairman Roberts.
Yes.
Thank you. It's unanimous.
Okay, who's going to present the legislative updates? Maria's not with us.
Well, actually, we have one more item. under the legal report.
Okay,
It's a discussion and the motion for declaratory order.
okay.
I'd like to go ahead and read an overview. A protest and petition for declaratory order has been filed with the Commission. Copies of the pleadings in this protest have been handed out to each Commissioner. The Commission has the authority under the UAPA to hear a declaratory order, which is to determine the validity or applicability of the Motor Vehicle Commission statute to a particular issue. Licensees can file a motion to petition the Commission to hear a matter between parties. Generally, the mechanism is by way of petition that is sent to the legal office as well as a motion. This motion allows the party or licensee to ask the Commission to hear a contested matter in the future. The Commission has the discretion and full authority to decide whether or not it will hear the matter and issue a declaratory order. If the Commission agrees to hear the contested case, legal will set the case on the next meeting date or one of the predetermined formal hearing dates. In the event that the Commission declines to hear the matter, the petitioner then has the right to file a motion with the Chancery Court to be granted a declaratory judgment. Today, the parties present are Hickory Hollow Kia, represented by James Cameron, and Kia Motors America Incorporated, represented by John Ross. If the Commission has any questions during the presentation, they can be directed to legal or legal counsel presenting today. Both parties are allowed to present their arguments starting with the petitioner, and then the parties may be questioned by Commission members. If the Commission decides to grant the motion, it is important to denote what the Commission is granting or denying. And with that, I will have Mr. Cameron come up.
Good morning. My name is Jim Cameron, along with J.D. Mason and the law firm of Bass, Sox, Mercer out of Tallahassee, Florida. We represent the petitioner in this case. It is a privilege to be in front of you today. It's also a privilege to sell automobiles in this state, whether you are a manufacturer, a dealer, or a salesman. A little bit of history. In 1955, our legislature recognized how important vehicle sales were to the citizens of the state of Tennessee. And we passed the statute that is basically the same statute under which you operate today. 5 years later, Ford Motor Company attacked this statute. And the case went to the United States Supreme Court. In 1960, the United States Supreme Court upheld the validity and constitutionality of our statute here in Tennessee. We are pretty much unique in that. A few years later, in 1978, the United States Supreme Court got to hear a challenge to the constitutionality of the California statute. That was the Orrin Fox case. The United States Supreme Court upheld the constitutionality of the statute again. In 1983, General Motors attacked the statute, and that statute once again was upheld, this time by the Tennessee Supreme Court in the Capital Chevrolet case that some of you may have heard me mention before in front of this body. In the Capital Chevrolet case, there are a couple of things I'd like to read you from what our Supreme Court unanimously said. It is the insistence of General Motors that prior to 1977, the statute did not involve the Commission in the adjudication of disputes between dealers and manufacturers. This is inaccurate. From their inception, the Tennessee statutes have given the Commission jurisdiction to revoke the licenses of manufacturers who dealt unfairly with dealers, including failing to make timely delivery of vehicles, inducing dealers to enter into improper agreements by threats to cancel franchises, forcing unneeded or unwanted merchandise upon dealers as a condition to renewing franchises, improperly terminating franchises, forcing dealers to accept deliveries by specific means of transportation, and entering into franchise agreements with dealers not equipped to provide consumers with services warranted by the manufacturers. The Supreme Court went on and said the previous statutes, which were sustained in pace, gave the Commission authority to resolve disputes concerning the termination of franchises. And then finally, quoting again from the Capital Chevrolet case, these boards or commissions, talking about you folks, are also empowered to promote fair dealings in the automobile business by preventing various trade practices and abuses, identifying and protecting the interest of the consuming public, and protecting dealers against the overwhelming economic power and potential abuses thereof by manufacturers. And that's what this petition is all about. This is a termination of a dealer's franchise, the death penalty that Kia Motors of America wants to render to this particular dealership, which we think is wrongful. We're not going into any of the substantive argument about that today. In 2013, we filed a petition for declaratory order on behalf of Gary Matthews Kia in Clarksville. That was, again, a termination case begun by the action of Kia in terminating or threatening to terminate this dealer's franchise. The matter was filed before you. You said you wanted to hear it. Kia immediately appealed it to the Chancery Court. The Chancellor ruled based upon a couple of factors. One being that Kia said, we don't have a right to be heard in front of the Commission. So there was a due process argument they raised. They also said, if you let the Commission hear this, we'll suffer irreparable harm because we'll have to pay legal fees. Folks, there is no case in the state of Tennessee that says paying legal fees is irreparable harm. That case was appealed by both the dealer and this Commission, acting through the Attorney General's office, to the Court of Appeals. While it was pending, the case was settled. And so there never was a absolute adjudication, finally, of the parties' rights or of the power of this Commission to hear one of these kinds of cases. In response to that, in July of 2015, you amended the rules of this Commission. And that amendment specifically provided that a dealer would have a right and the manufacturer would have a right to come and present their evidence before this Commission, and you could issue a declaratory order that would say either the action by the manufacturer would violate our statute or that the action by the manufacturer would not violate our statute, and that termination was proper. You all passed that. The Attorney General passed it, approved it, and on January the 11th, 2016, Mr. Glandorf, on behalf of the department, presented it and explained it to you that this was so that it would clarify the law that everybody had a right to come and be heard in one of these kind of cases. So what we're asking you to do today is two things. One, pass a motion that says we want to hear this case. Second, set the case for hearing. There is a provision in the Administrative Procedures Act that says when one of these kind of cases comes before an agency or a commission, it must be set within 60 days. If it's not, it's deemed rejected. That's why we filed a motion to set. That's why we're asking you to simply do two things today. I think that it ought to be set, not at the next meeting, but at the meeting after that, simply because if this case does move forward on a contested basis, the parties will have to engage in discovery. There will be experts, there will be depositions, and all of that kind of stuff. You can't do that in 3 months. So we're simply asking, set it 2 meetings off. My friend John Ross, who represents Kia, has said that they do not intend to terminate this dealer's franchise until or unless there is a final adjudication that says that that termination would be proper. So the dealer is not under an immediate threat. We do want to move the case. We do want to get it before you. There is a mediation, I will tell you, between these parties set on February the 18th. Our 60th day runs out February the 17th, and you won't be meeting before then. That's why we're here asking you to do this today. They are going to argue that this chancellor ruled that you did not have the power to hear one of these kind of cases. We believe that chancellor was absolutely dead wrong. She has since retired. She will not hear this case again. We believe that was wrong, just as the chancellor in the Capital Chevrolet case was wrong. When this commission ruled in favor of the dealers in the Capital Chevrolet case, General Motors appealed it to Chancery Court. And that chancellor said what you did was unconstitutional and wrong. That chancellor was absolutely wrong. A chancellor cannot overrule the Tennessee Supreme Court. And the Supreme Court has spoken and has said, you have this power and this duty. And if you think about it in terms of the privilege to do business in this state, that subjects you to some regulation on the part of the state of Tennessee. Whether we call it leveling the playing field, whether we call it giving everybody a fair shot, that's what we're talking about. You have the power, you have the responsibility, in my judgment, to hear this case. And today, that's all we're asking you to do. Pass a motion to accept the case and hear it and give us a date. Are there any questions before I? Thank you, Mr. Chairman.
Will we hear from anyone else?
Not from our side.
Okay. Mr. Huffman, what else?
I believe Mr. Ross is going to speak.
Members of the commission, my name is John Ross. I'm with the law firm of Neal and Harwell, and we represent Kia Motors America in this case. We represented Kia Motors America in the prior case involving Gary Matthews that Mr. Cameron referred to. We have filed a response to this request that a declaratory order proceeding be commenced in this case. We have opposed it, and the reason why we have opposed it is that we do not believe, respectfully, that the Motor Vehicle Commission has jurisdiction over this type of controversy. Generally, a petition for declaratory order, according to the Commission's regs and to the law in regard to this, the facts are generally set out in the petition, and then the adjudicating body expresses an opinion as to how the plaintiff is affected. And indeed, the regulation that this commission has filed does exactly that. It sets out the content of what the petition is supposed to specify, and that regulation requires the party that's seeking the plaintiff in the case, requires that party to set forth in the petition how his contention as to how the statute affects him. Now, what is going on here is Mr. Cameron needs to be in Chancery Court. He is essentially alleging breach of contract. You say, well, does the commission have anything to say about this? You certainly do. TCA section 55-17-114 C20 deals with dealer addition cases, and it provides a procedure whereby the affected dealer who is having a competitive franchise put in his relevant market area comes into the commission and alleges why this shouldn't be allowed. There is a specific provision in the statute dealing with this. The statute was originally enacted clear back before in 1955. There was a facial challenge to the constitutionality of the statute by Ford Motor Company at that time. The constitutionality of the Motor Vehicle Commission statute as it existed at that time was upheld by the Tennessee Supreme Court. The next step in the sequence in regard to TCA 55-17-114 C20 occurred in the General Motors case, and that was a dealer addition case. General Motors Chevrolet sought to add a fifth Chevrolet dealer in Nashville at that time, and the litigation was under subsection C20. Now, what happened in that, the chancellor did strike down the statute as unconstitutional, and the Tennessee Supreme Court reversed and said the statute was unconstitutional. What was constitutional, excuse me, I misspoke. We're not challenging the constitutionality of the statute today, but we do not think that this commission has jurisdiction over this particular kind of dispute. If you look in the statute under C20, they have a detailed provision whereby the protest is filed with the commission objecting to the establishment of a new dealer in that dealer's relevant market area. And these things generally require expert testimony both from the dealers and from the manufacturer or distributor involved. And the bottom line is that if you look at, and you folks are at a disadvantage, the disadvantage is this is essentially a legal argument. And you folks are very sophisticated business people, and you sit on this commission, and each of you folks are intelligent people. I recognize that. That's always been the case. But the fact is, this is a legal question that is being presented today. Mr. Cameron, in his petition for declaratory order, says he alleges a violation of subsection 3, C3, not C20, but C3. And that is unfairly or without due regard to the equities or without just provocation, the manufacturer or distributor has canceled or failed to renew the franchise or selling agreement of a motor vehicle dealer. It does not have the provision in there that C20 does, providing for a hearing on the issue before the commission. That is not in there. Now, the fact of the matter is, as a legal matter, the Motor Vehicle Commission, just like any administrative agency of the state of Tennessee, only has such power as the legislature gives the commission, gives that administrative agency. Now, certainly, the legislature, when it amended subsection C20 in 1977, had the power and granted the power to the commission to conduct a hearing under subsection C20. The legislature certainly knows what is in the statute. At that time, if they had chosen to allow that same type of hearing, which is what Mr. Cameron is requesting on behalf of his client, they knew how to change the statute because they'd done it in C20. They did not do it in C3, nor did they do it on C21. Mr. Cameron mentions that, but his initial protest doesn't mention subsection C21. It has the same lack of statutory language to enable the case to be heard by the commission. Now, the bottom line on this is that the commission does not have the legal authority to grant itself jurisdiction that the legislature has not seen fit to confer upon this administrative agency. And so we have made the argument in our brief, and we filed 2 of them. We made the argument in our briefs that this particular regulation that was passed by the commission and is set forth in the regulations, in the Tennessee regulations, is not a valid exercise of the commission's power, because the commission does not have the power or the right to grant itself jurisdiction to hear a case that the legislature has not authorized the commission to hear. And under TCA section 1-3-119, it says, in order for legislation enacted by the General Assembly to create or confer a private right of action, the legislation must contain express language creating or conferring the right. The legislation here in C3 and in C21 does not give the commission the right to hear this type of case, this dealer termination case. Now, the regulation involved says this. This was enacted by the commission, and it deals with the content of a petition for declaratory order. It says it must be a statement of facts of the controversy and a description of how this rule, order, or statute affects or should affect the petitioner. And the petitioner here is the dealership that Mr. Cameron represents. What he's trying to do is he's trying to say, have the commission adjudicate how this statute affects the manufacturer or distributor. This is not authorized by the commission's own regulation. But the regulation in question in subparagraph 2, and this is Tennessee Comp R and Regs 0960-01-.06. In subsection 2, the commission, on its own motion, provides for a hearing sought in this case as to C3 and/or C21. That's dealing with dealer termination. However, the legislature did not authorize this. The commission, on its own volition, enacted subsection 2 following the decision of the Chancery Court in the Matthews-Kia case. And the decision of the Chancery Court, we have cited that in our response, and this is what the Chancellor said. If I can locate the opinion here. It's attached as Exhibit A to our the memorandum in order was entered by the Chancellor following hearing oral arguments and the filing of briefs, and the Chancellor basically said in this case, which is, we lawyers would say the case is on all fours with this case. That means it's virtually identical. And what she said was, although Matthews, in that case, filed for administrative review, it did not seek revocation or suspension of Kia Motor America's licenses. And that's what the commission can do to protect this dealer. It can revoke the license of Kia Motors America. But Mr. Cameron hasn't asked for that, and there's an obvious reason. That would put every Kia dealer in Tennessee out of business if Kia Motors America had its license revoked. They've done nothing to require it to be revoked. And the bottom line is that in that memorandum in order, the Chancellor disposed of that case on page 4. He said, Matthews, and you could just as well substitute where the Chancellor is saying Matthews with Mr. Cameron's client, said Matthews appears to seek statutory authority for a declaratory judgment through the APA, the Administrative Procedures Act, a procedure in which an affected party may obtain a declaratory order to declare how a statute or rule affects the party, how it affects the party, not how it affects an adversary. Matthews, however, is not asking the Commission to declare if or how the Licenses Act applies to Matthews, which is what is required under the Commission's regulations. But rather to declare that a private party, KMA, Kia Motors America, is pursuing an unauthorized or unlawful course of action. The APA does not provide the Commission with authority to adjudicate private termination disputes, and the Commission does not derive such authority when the Administrative Procedure Act is invoked. And that's the position the Commission finds itself in today, with one exception. And the exception is the Commission sought to get around or distinguish the decision of the Chancery Court. And incidentally, the Commission was bound by this. The Attorney General's office appeared and argued the case on behalf of the commission, and Mr. Cameron was arguing on behalf of Matthews Kia in Clarksville. And the bottom line was the commission sought, by virtue of changing the regulation, to confer jurisdiction upon itself. The commission, with due respect, does not have the legal power to do that. It can't do that. Now, we cited some case law that when the commission does that, when it's not done by the legislature and they purport to do this, the Tennessee Supreme Court in the Methodist case, the Court of Appeals said that in the Methodist case that the action of the commission in enacting this is a nullity because you can't confer jurisdiction on yourself. And your attempt to do so, the courts have said, is a nullity. And when KMA came in and we filed these briefs, we reserved the right to seek relief before another tribunal if the commission tries to exert jurisdiction over KMA, Kia Motors America, in this case, in the manner in which it sought to do in the Clarksville case involving Gary Matthews Kia. The bottom line is the commission does not have the authority, the legal authority to do that, to do what has been done. And subsection 2 in the regulation, it was a regulation enacted by the commission that was amended, and the amendments were filed July 7, 2016. That was after the Chancery Court's decision in the Gary Matthews Kia case. And it was also enacted, and it was to be effective October 5, 2016. Though it may be effective on that date, it is not a proper exercise of power of the commission. It goes without saying that the commission, since it's a creature of statute, just like every administrative agency, cannot expand its jurisdiction beyond what the legislature has given the commission. The commission, if you look at subsection C20, plainly has the right to conduct hearings in dealer addition cases. There's an elaborate procedure, and I've been involved in a number of them on behalf of automobile manufacturers, one motorcycle manufacturer many years ago, and it turns out that Mr. Cameron oftentimes was on the other side. We know each other very well. The fact of the matter is, and we respect each other, the bottom line is, though, Mr. Cameron is wrong in urging this commission to take jurisdiction here. And we know he said the filing of an appeal. The appeals were dismissed in the Gary Matthews Kia case. The law is as stated, as I've read it to you, there in the Chancellor's opinion in the Gary Matthews Kia case. And Jim Cameron's right. Carol McCoy was the sitting Chancellor, so she will not hear it, but that Chancellor will look at the decision because it's going to be brought to his attention or her attention, and we will bring it to their attention and ask that if need be, if the commission determines to proceed, we will take the necessary steps to stop the proceeding. We don't believe it's a lawful proceeding for the reasons I've stated, and I say that with great respect for the commission and its members. But the plain fact of the matter is that you're at a bit of a disadvantage. This is a legal question that ought to be argued by lawyers. It is, and you folks get to listen to it and try to sort it out, and it's not so easy, I recognize. But the bottom line is that the decision of the Chancery Court in Gary Matthews Kia is controlling here, and ultimately, and so as it stands right now, this the law is that the state of Tennessee is bound by, because the Attorney General was involved in that case on behalf of the Motor Vehicle Commission. And I said the Deputy Attorney General, Ms. Knack, was involved, and Mary Ellen Knack. And the bottom line is that this proceeding should not be permitted to go forward in this commission. Mr. Cameron is interesting. He's filed a motion for leave to amend because his initial pleading didn't mention a petition for declaratory order, I don't think. So the bottom line is he's made it clear now that he wants a declaratory order, and he's relying upon this provision, subsection 2 of the regulation 10 Comp R and regs 0960-01-.06. He's relying upon the action of the commission back in 2016, basically seeking to reverse the Chancery Court's ruling in the Gary Matthews Kia case. However, the commission's effort to do so is not effective. It's a nullity, according to the case law, because you cannot grant jurisdiction to yourself. It must be done by the Tennessee legislature, and the legislature has not granted the right to conduct a similar proceeding like under C-20, where there's a dealer addition to a dealer termination case. And I've gone on at some length, and I apologize for being so lengthy, but I appreciate your kind attention, and I ask that you dismiss this petition and not allow a petition for declaratory order to go forward. It's he's not asking, as the regs of the commission require, to how this this statute affects him, but he's trying to have the commission adjudicate basically a breach of contract action, which properly should be brought in Chancery Court at the outset. So thank you all very much. I appreciate your attention.
Briefly, the fallacies in Mr. Ross's argument are that whether he's here representing General Motors or whether he's here representing Kia, he's trying to put you in a box and say you can't do, you don't have jurisdiction. The Tennessee Supreme Court ruled in Capital Chevrolet you do have jurisdiction, period. He also would like to imagine that the Administrative Procedures Act was not adopted in Tennessee in the late 1970s, early 1980. That act provides that you, like other boards and commissions, can entertain a declaratory order, look at the facts, and apply them to the law. The law in this state has always been, and Mr. Ross quoted it a minute ago, that it is a violation if a manufacturer unfairly or without due regard for the equities or without just provocation cancels or fails to renew the franchise of a motor vehicle dealer. So you can, and if you look at what we're asking you to do, it makes sense. We're saying, look at all the facts, determine that it either does violate our statute or does not violate the statute. That way, both parties know what the status is. Mr. Ross made reference to the fact that we would put in jeopardy every other Kia dealer in the state if you rule against them. That's not true. You've got the power in this particular regulation. You've got the power to say that if you go through with this, it's going to violate our statute, and you are going to be subject to certain penalties we can impose, one of which is refusing to license a replacement dealer in the same market where you're trying to kill this one. So you've got a lot of remedies. All we're asking for is a declaratory order that'll set the table and tell the parties what's going to happen in the future if this action is carried out. Thank you.
Commission have any questions?
What does the Chairman Roberts, and do we at this point are we ready to take motions from the floor from the commission?
Well, let me give you just an overview of what we're doing today.
Okay.
There's only one question, and that is through when a declaratory order is filed under the UAPA, the commission has one question, whether they want to hear a contested case or they don't. If you want to hear the case, we will set it probably in July at the next meeting. If you do not want to hear the case, then they have other avenues to go to through Chancery Court. Under the rule 0960-01-.06, upon filing of a declaratory order, the commission shall convene a contested case hearing for the purposes of determining whether the action of the manufacturer or distributor is A, unfair, B, without due regard to the equities, or C, without just provocation as provided within the statutes that were quoted to you. That is TCA 5517-114C3 and or C21. This rule was effective October 15, 2016, which was after the Chancery Court decision, and it did go through the channels, and Government Operations Committee did approve it, of course. So today, what you would do is make a motion to either hear it or deny it, and then we'll do a roll call, and at that point, then we'll decide whether we set it or not.
Under the rules, is the chairman able to make a motion?
I don't think so.
I'd like to make a motion that to grant the petition for declaratory order to allow the Tennessee Motor Vehicle Commission to hear the case number 2019-10167, Hickory Hollow Acquisitions DBA Hickory Hollow Kia, Greenway Kia versus Kia Motors.
Second it.
Any further discussion? Executive Director Lawrence, will you call the roll on this vote?
Yes.
Commissioner White?
Yes.
Commissioner Murray?
Yes.
Yes.
Commissioner Chobanian?
Yes.
Commissioner Barker?
Yes.
Commissioner Fox?
Yes.
Commissioner Galvin?
Yes.
Commissioner Norton?
Yes.
Commissioner Vaughn?
Yes.
Commissioner Jackson?
Yes.
Commissioner Kramer?
Yes.
Commissioner Evans?
Yes.
Commissioner Tomaso?
Abstain.
Chairman Roberts?
Yes.
Now, do we make a motion to set it for the July hearing? If that's when y'all want to set it?
Make a motion. So moved.
The date on that hearing?
What is the date?
Those,
July 14th through 15th?
yes.
Would include those dates in my motion, Mr. Chairman.
just as a question, if the parties both counsel for both parties come and say, can we move this to the October meeting as opposed to the July meeting, okay.
Yeah, they can make a motion.
That's
to
their,
continue.
okay, because we don't know what's going on in the background, and
Right.
that July may be, there may be close to something, and don't want to hear it in July.
But we can set it whenever, well, I know that there was a request for the July meeting, but
A motion is for the July dates that we mentioned.
I'll second.
Any further discussion on the date setting? If you will, call the roll again.
Okay, and this is to set the hearing for the July meeting, July 14, 15. Commissioner West?
Yes.
Commissioner White? Yes. Commissioner Murray?
Yes.
Commissioner Melton?
Yes.
Commissioner Chobanian?
Yes.
Commissioner Barker?
Yes.
Commissioner Fox?
Yes.
Commissioner Galvin?
Yes.
Commissioner Norton?
Yes.
Commissioner Vaughn?
Yes.
Commissioner Jackson?
Yes.
Commissioner Kramer?
Yes.
Commissioner Evans?
Yes.
Commissioner Tomaso?
Abstain.
And Chairman Roberts.
Yes.
Motion carries.
just want to say on the record that the legal department will reach out to the attorneys about setting this.
Mr. Roberts, this is John Ross.
Can we amend that now, so we don't have to come back in again?
All we need is a date, and I'll work.
Why don't we do October?
We've already voted for
Yeah,
July.
but can we?
We can do
They can adjust it. They can always
They-
adjust it and
yeah.
come back to us.
Okay.
We've just voted July, so.
Yeah.
Yeah,
it's-
I know that.
Yeah.
Okay.
Mr. Chairman, I can withdraw that motion if I need to for a date change.
Clarity
You
on
make
that?
a motion to strike.
So moved.
In a roll call vote.
We don't have a second yet.
Oh.
Yeah, we
after
need a
the
second.
No, wait, let's
To
get some
strike-
clarity here.
Yeah.
We're striking what?
The original date that we just set, we're going to strike it.
And move it to October? We need a date.
Does it matter? We don't normally set the.
I think you just strike it and then you make a motion
Okay.
for
Can't you just leave it in
for the
July
next
and let
date.
them
I think
adjust it?
we need a date on the calendar.
Can we leave it July?
Just leave it July, and if the parties want to change it, we have no problem with that.
Yeah. Just leave it alone.
Unless council,
That's fine. Leave it alone.
I mean, it may be January of 2021 for this.
We will actually be filing the contested case, and then if they want to continue it, then we will file a motion to continue to whatever other date.
Okay, well, let's just leave the July if the board is.
We can do that.
There's no reason for me to strike the strike because there was never a second.
There's never. The strike failed for lack of a second.
Okay, now we're on to other matters. Legislative updates. Who's going to present that?
I guess I'm doing that too.
Okay.
There were only two updates that Maria asked me to present. We had the sunset hearing, and this commission was given 6 years, another 6 years. And the next meeting, we will need to have a rule committee meeting. There has been a change in the auctioneer's rules. One of the requirements for a motor vehicle auction license is that you have to present an auctioneer license, and that auctioneer license has been removed. So we will need to make a change in the rules where the auctioneer license is not required to get a motor vehicle auction license. So, but we'll discuss that in the next meeting, the rule committee. And that's the only updates I have.
All right. Do we need to have a motion to accept your legislative update? Do we need one?
Yes.
Motion?
So moved.
Second?
Second.
Okay. Any further discussion? Executive Director Lawrence, would you call the roll?
Commissioner West,
Yes.
Commissioner White,
Yes.
Commissioner Murray,
Yes.
Commissioner Melton,
Yes.
Commissioner Jopani,
Yes.
Bedian, Commissioner Barker,
Yes.
Commissioner Fox,
Yes.
Commissioner Galvin,
Yes.
Commissioner Norton,
Yes.
Commissioner Vaughn,
Yes.
Commissioner Jackson,
Yes.
Commissioner Kramer,
Yes.
Commissioner Evans,
Yes.
Commissioner Tomaso,
Yes.
Chairman Roberts.
Yes. So I don't believe we have any committee reports to go over. Any new business? Absolutely.
I apologize for the delay, Mr. Chairman. I believe we have a guest here today who had thought about possibly addressing the commission on basically the discussion of fees that we engaged in earlier, but I think they would prefer to maybe set up a rules committee meeting and then perhaps have that discussion take place there.
Okay. Do we want to set that up now?
I would suggest that we go ahead and set it now.
Okay. And
That we can set a meeting for the Rules Committee for our next meeting, beginning of it.
is that soon enough to take care of this?
Beginning or end of I guess the end of it would probably be better, wouldn't it? After.
That would be at the end of the,
Or you want to do it tomorrow? I mean, can we?
When's the next committee meeting?
We don't have a committee meeting set up yet.
Yeah, we don't have any committee meetings set up for tomorrow, but that day is set aside for committee meetings. I'm just, at the pleasure of the board.
Since I didn't plan for that, I would really prefer not to, and as you can tell,
Yeah, okay.
it might be a good plan.
Why don't we set that for April?
Oh, thank God.
we have a committee meeting date of May 5th, or we can do it at the quarterly meeting in April.
Either way works for me.
Do we need the time to make it on May the 5th, or can we do it?
You can just do it.
Okay. Okay,
Do it
we'll do
on
it in April.
April?
Any old business? Do we have a motion to adjourn?
So moved.
Second.
All right, no further discussion. All those in favor say aye. Aye. Opposed? We are adjourned.
Good job, John.
Did you get through it?